Good afternoon, everybody. I can see the participants are all online. My name is Dilber Devitre. I'm an associate in Homburger in Zurich. It's my pleasure today to introduce this last panel, unfortunate last panel of the India ADR week. We're going to end this panel this week today with a very, very interesting session on a very interesting topic, very interesting debate. We're going to be debating today about double hatting, and is it hazardous to international arbitration or not? And we have a very illustrious panel before us today who's going to be talking about this. Several of them are arbitrators and counsel, so it would be very interesting to hear their positions. It's my pleasure to introduce this council to all of you today. I will start with our moderator, who is Mr. Promit Chatterjee, who is joining us from Delhi. He's a principal associate at P&A Law Offices, which is also the law firm that is sponsoring this session. So thank you very much for that. His practice focuses on international commercial arbitration and investor-state disputes, and he is dual qualified as a lawyer in India and also as a solicitor advocate in England and Wales. So thank you so much, Promit, for moderating this session today.
Thank you.
We then also have Amit Kumar Mishra with us, who leads the dispute resolution practice at P&A Law Offices. His practice also focuses on international arbitration. He regularly advises the government of India and various public sector undertakings in India on their dispute strategies. And he is also a visiting faculty member at the National Law University, Delhi, and the Jindal Global Law School. So thank you, Amit, for joining us today.
Thank you.
Also joining us is Dipen Sabharwal, a QC, who is a partner at White & Case, and who serves as the head of the EMEA arbitration practice at White & Case. Dipen also advises on complex cross-border disputes, and he also is a lecturer at King's College and teaches advocacy skills for the Foundation for International Arbitration Advocacy. He's also a QC and was the youngest solicitor advocates to take silk. So we're very, very, very privileged to have him with us today as well. Thank you for joining us, Dipen. Finally, our fourth speaker is Epaminontas Triantafilou, who is also a partner of Quinn, Emanuel, Urquhart & Sullivan, specializes in international arbitration, also based in London. We have quite a prominent London presence on this panel today. He has also been involved in a lot of arbitrations as counsel and also as arbitrator, sole and presiding arbitrator in several high-value disputes. So it would be very interesting to hear his perception also on this issue that we are going to be debating actively today. And finally, we have Mr. Stephen Finizio, who is a partner at Wilmer Hale. He is in the International Arbitration and Dispute Resolution group of Wilmer Hale. He is also a very active counsel and a very active arbitrator. So also somebody who can give this perspective on the issue, interesting perspective on the issue we are going to be discussing today. And he's also a teacher and an adjunct professor at SOAS University of London and teaches international arbitration in London. So as you can see, we have a very, very distinguished panel before us today, and I look forward to a very interesting debate on this topic. I'll hand over to you, Promit. Thank you so much.
Thanks, Dilber, for the kind introduction. Ladies and gentlemen, we at P&A are delighted to welcome you to this exciting debate on the motion, is double hatting hazardous to international arbitration? After a week full of riveting analysis of complex issues affecting arbitration and ADR law, we felt the only way to top it all would be to pit arbitration heavyweights against each other on an issue which sheerly reeks of controversy. The panelists have promised to do their very best to defend their turf, so long as they issue the necessary disclaimer. Whatever they say at this debate should not be later held against them or be construed as their personal opinion on the matter. Now, to put the motion of this debate to context, double hatting refers to the practice of the same person acting as counsel and arbitrator simultaneously in different arbitrations. This draws criticisms from some quarters on the basis that performing such overlapping roles can affect an arbitrator's ability to act impartially. This criticism probably becomes more acute in investor-state disputes, where similar questions of law are more likely to arise across arbitrations. This can lead to a situation where an arbitrator is tasked with adjudicating a legal issue, which he has also previously dealt with as a counsel. Apart from issue bias, there are also inherent questions of apparent bias arising out of such conflicting roles. These have even led to instances of annulment of arbitral awards, such as in the case of ISA versus Spain. On the other hand, an outright ban on double hatting would also make it all the more difficult for new entrants from diverse backgrounds to get their first break as arbitrators, who may not yet have the financial resource to altogether give up on their existing counsel practice. Therefore, the jury is still out as to how to draw a balance between these competing concerns, which is why all the more this debate promises to be exciting and engaging. Amit and Steve will speak for the motion, while Dipen and Nontus would speak against. Now, before I mute my mic and hand over the stage to the stellar panelists, we would like to take a poll to gauge which way the audience tilts at the start of the debate and before hearing the panelists. We'll try to take another poll at the end. The side which is able to swing the audience votes would be the winner. To clarify, let's say if 60% of the audience polls in favor of the motion now, and this percentage changes to 55 at the end of the debate, then Dipen and Nontus will be the winners. So can I request MCIA to start the poll, please? Can we put up the results? Okay. So 72% of the audience think that double hatting is indeed hazardous to international arbitration. I leave the floor open to the panelists now. Just two housekeeping points. I would request each speaker to try to limit their speech to around 10 minutes each. And I would also request the audience to post their questions using the Q&A or chat functions. We'll try to take a couple of questions towards the very end, depending on how time permits. Thank you. Over to Amit.
Thank you, Promit. And I didn't encourage this. I didn't feel that this polling would be 72% for the motion, although I thought that, this is something when I go in for speaking that double hatting is hazardous. We did think that, that is something against the norm in India at least. But anyway, what I propose to speak for the motion today is on a very specific area, which Promit has already highlighted, and which is something of a concern, which is the issue conflict. Now, as Promit has already explained, the concept of double hatting basically means whether a arbitrator and counsel can simultaneously act on a particular issue in the context of what I'm going to speak, and whether that is something we should encourage or that is something we should completely be prohibiting. And as I endeavor to present in the course of my speech for next 10 minutes, how this has on several occasions led to even a challenge to arbitrators, and on certain occasions even challenge to an award. Basically, I was addressing the area of issue conflict, and what I was presenting is an example whereby, say, if in the morning today, I as a counsel in a case have presented my views on a particular issue, and say in the coming week or in the coming month, I happen to be an arbitrator on the same issue, there is a scope and there are issues which arises whether on the same issue, which is an issue conflict, which will I have an independence challenge, or can there be a challenge of impartiality? As you will see in some of the cases that I plan to deal with, this issue has been taken up as an issue conflict, and courts have, and the deciding authorities have in those cases accepted the challenge or the problem of the issue conflict, and on certain occasions have upheld the challenge to the arbitrators. Now, let me deal with few of these cases which are noteworthy, like in the case of Bank of Montreal versus Brown, which is a case of 2006. The court actually disqualified the arbitrator for simultaneously acting as a counsel against one of the parties concerning an unrelated dispute in a different field of law, but on the same issue. The court noted a reasonable apprehension of bias must not be confused with the actual bias, and therefore there was the apprehension of a bias that on the particular issue, since the arbitrator is already acting as a counsel, there is a scope that his views are already prejudiced, because he would not want to have a decision as an arbitrator which can be used against him in the case where he's acting as a counsel. In similar another case, which is ICS Inspection and Control Services versus Argentina, this is a relatively newer case of 2009. The respondent challenged the arbitrator appointed by the claimant, who with his law firm in that case was simultaneously representing investors as the counsels in another ISDS proceedings. The deciding authority interestingly used the phrase that the arbitrator's role as a counsel places him in a situation of adversity against the respondent in that case. And it says that it gives rise to a justifiable doubt as to the arbitrator's impartiality. Now, another case, if I may deal with, which is a case of Exteco versus International versus Peru. This is a recent case of 2014. The respondent in this case successfully challenged the arbitrator appointed by the claimant on the basis that the arbitrator had advised and was concurrently, simultaneously advising a number of respondents' public entities in a number of unrelated matters, but on the same issue. Similarly, in this case, the deciding authority concluded that the circumstances does exist, which do not go to the arbitrator's independence, but definitely give rise to justifiable doubts about the arbitrator's impartiality on this issue. So basically, the point to be noted is that the issue of the area of issue conflict is a serious one, which has on various occasions led to a justifiable doubt as to the arbitrator's impartiality and has been a successful ground of challenge to the arbitrator's appointment. Now, this has actually traveled beyond the judicial challenge. And when I say it's traveled beyond the judicial challenge, I mean that the various governments or the executives have picked this up and have sought to incorporate it as a bar or a ban on certain occasions in their agreements. Now, this conflict is very acute in a case of investor-state arbitrations. Why so? Is because in more than often, the arbitrators are called upon to interpret similar, if not identical provisions in the BITs. As you know, this is a very small world. Almost all BITs are similar worded. And if a particular person has already acted as a counsel and given a view or has presented his case as a counsel on a particular interpretation of the BIT clause, and if it is same, almost similar clause in another BIT where he acts now as an arbitrator, there is a very, very much genuine apprehension of his impartiality on that particular issue. To give you a few examples where this has now been sought to be incorporated in the agreement as a ban, is a very recent agreement of comprehensive and progressive agreement for Trans-Pacific Partnership, CPTPP, as we call it, which was brought into force in 2018, has a clause which clearly says that upon selection, an arbitrator shall refrain for the duration of the entire arbitration proceeding from acting as a counsel or party appointed expert or even a witness in any pending or new investment dispute under the CPTPP or any other international agreement. So it's almost a good, amounting to a good bar. Similarly, the Canada-European Union Comprehensive Economic and Trade Agreement, or the CETA, as I call it, has a clause which says that the members of the Permanent Investment Tribunal under CETA shall refrain from acting as a counsel or a party appointed expert or witness in any pending or new investment dispute under the CETA or any other international agreement. The last of the examples being the US-Mexico-Canada Agreement, or USMCA, which is as early as last year, 2020, which was brought into force, clearly says that it basically prohibits an arbitrator appointed under Chapter 14, which is the investment-related chapter, from acting as a counsel or party-appointed expert or even a witness in any proceeding under the USMCA. Now, these are examples of the multilateral organizations, treaties, which, as I have sought to lay down, they are prohibiting the concept of double hatting. Interestingly, states are picking up, and in the model BITs, and some of them that I shall now elaborate, are also going ahead and are encouraging a ban on the double hatting. The most novel example being the 2019 Netherlands model BIT, which is specifying clearly that the members of the tribunal shall not act as a legal counsel, or in fact, in past, should not have acted as a legal counsel for the last 5 years in any investment dispute under that agreement or any other international agreement. So basically, it is not only a prospective bar, it says for any appointment in your last 5 years, if you were acting as a counsel on this particular issue, you may not be appointed as the member of the tribunal. Now, similar clauses exist in the 2019 Slovak Republic Model BIT, the Morocco Model BIT of 2019, and also the Model BIT of the South African Development Community, which is a 2012 model. In nutshell, in conclusion, if I can say, India Model BIT does not have this clause, but that's because it's a very common practice where counsels in the morning are acting as the arbitrators in the afternoon or post-lunch session, and it's a concept not at all frowned upon, and that's why I was very surprised with the poll. And that is something I thought, many counsels in India will not be happy with for the motion speakers, but it's an increasing trend internationally where people are discouraged. It has led to a severe and a successful challenge. States are picking it up as a ban or a complete prohibition in their model BITs and in the multilateral treaties that are coming forward. And I end this debate on my part by saying that is something which should be encouraged. It definitely leads to a conflict on the issue or the same question which the council may have dealt with and has to deal with again as an arbitrator. Thank you very much.
Thanks, Amit, for capturing the legal developments around this issue so nicely and basically rallying support from all states except India for your position. I would now request Nontas to present his points against Amit.
Thank you very much. And of course, thank you, Amit. I noticed that the presentation just made by Amit so ably focused on investor-state arbitration. And I will address that, of course. But I want to start by saying that the topic here is double hatting in international arbitration writ large. And there are some very significant differences between the more specialized field of treaty arbitration and the broader field. The key difference, which Amit, of course, identified, is that treaty arbitration is based on the adjudication of relatively similar instruments across the world. Investment treaties, for those who haven't seen them, are both surprisingly short and surprisingly similar. That's changing, of course, with new generations of treaties. They're becoming a lot more elaborate in their provisions. But the treaty protections that arbitrators deal with in investor-state cases tend to be worded in a similar fashion or tend to have similar legal effects. So there is actually a pronounced issue with taking counsel positions on one type of protection in the morning and then adjudicating the very same provision in the afternoon. Now, I do want to say, however, even within this very limited field, that the motion, or at least the concept behind the motion, is focusing a little bit too much on the difference in mindset between advocacy and adjudication. There seems to be some sort of instinctive reaction that once one is counsel for something, they cannot think fairly about the issue when they have to resolve it. And I question that premise on a number of grounds, which of course time prohibits me from going into great detail. But first of all, it's not true that counsel are expressing personal opinions when they're arguing for a case. This is actually exemplified by this panel today. It's about arguing a particular case. It's about putting forward the client's case. It's not about expressing a personal opinion. So why necessarily advocating for a position in the morning would reflect on that particular person's own adjudication of a particular issue as arbitrator in the afternoon is not quite an automatic inference. It's not immediately clear. The second point is that while we're on issue conflict in particular, why are we giving a free pass to other types of personal bias, if you will, or types of things that could influence one's judgment beyond counsel roles? What about academic roles? There's people out there who are writing books left and right about the legal effects of treaties, then get appointed and are presumed in most instances to be able to resolve the same legal issues impartially. And there's nothing saying that those books are not their positions. They actually are presented as their personal positions. So I'm just trying to say that it's not quite that clear that the counsel role is what disqualifies one or should disqualify one then from serving as arbitrator. There's all sorts of other functions that one could be performing in the legal field, which could raise questions about independence and impartiality. So there's, I guess, not just two hats, but multiple hats that one needs to be aware of when deciding to wear the arbitrator hat or not. But stepping back a bit from this, and I'm sorry, but I should also mention then there is the financial conflict issue. I differentiate that from the issue conflict, because Amit also mentioned cases where, for example, there is a partner in a law firm, their law firm is acting in another case, then, and you can say that that partner then is benefiting financially from the conflict. That is not an issue it's not an issue conflict, it's a financial conflict. And that is an entirely separate nature of problem, which of course is typically dealt with very swiftly by disqualifying arbitrators. But I'll step back a little bit from the treaty field and talk about international arbitration generally. And Promit opened this session by saying, how are we going to give new arbitrators opportunities to appear? Perhaps here it's worth highlighting there are some natural barriers into an arbitrator career. One is experience. And what kind of experience, one would say? I would argue it needs to be practice experience, market experience, practical experience with the legal issues that you're going to be called upon to resolve. I mean, we should be paying homage here to the roots of international arbitration in the commercial sense, going back to the medieval guilds in England, where merchants wanted other merchants to solve their problems because they understood trade practices best. We don't want people who are completely divorced from the issue they're adjudicating to just come in and try to learn everything anew. That defeats the whole purpose. We may as well just go to generalist judges and have decisions rendered there. So I think there is an issue here about entry and giving young lawyers who most of the times begin their professional lives by practicing an opportunity then to see the other side of the table or to go up on that bench in a virtual sense is an extremely valuable thing for the field and for them and for their careers. The other barriers that you can see is remuneration. Oftentimes, arbitrations, you don't have enough to make a living for yourself, even if you decide to be a career arbitrator. It takes a long time to become known in the market, to become selected. It is a market. So again, it's not something that you can you can start doing from the outset. And it is necessary for a stage in your life to be able to do both if you are going to transition even to a full-time arbitrator role. So it's almost like a necessary bridge. And if one factors in conflicts, you start seeing that it's actually not quite that easy to double hat in the first place. And emotion completely trying to ban the practice exaggerates the problem, creates barriers, and then naturally favors certain types of people. For example, ones that are in academic positions and therefore don't have any income insecurity in most instances, who can then have the luxury perhaps of dabbling into arbitrations as and when. Non-coincidentally, those tend to be the most vocal advocates against double hatting, again, in the broader field, not just in treaty arbitration, where there are some specific concerns. So again, in terms of the overall problem of double hatting, and there are actually studies out there about the extent to which it actually happens, it doesn't happen that much in the first place. It is safeguarded against by all sorts of provisions in arbitral rules and ethical rules, as well as guidelines such as the International Bar Association's famous guidelines, which are out now being applied pretty much in all arbitrations, either by express adoption or implicit consultation by tribunals and appointing authorities. And the practical considerations that underlie assuming an arbitrator appointment. And this is what I'll close with. The practical considerations here, quite apart from all the other points, are how are you going to present yourself in a market? Arbitration and the strength of arbitration is that it's a market. Arbitrators don't just get appointed randomly. They get selected because of a certain reputation they have built. And everybody knows that reputation is like a crystal glass. It takes a long time to build, but it can be very easy to break. And if you are the sort of person who will get caught in a serious conflict, in a serious ethically compromised situation, chances are that you're endangering your career as an arbitrator just from the outset. Most people refrain. The people who get caught never get appointed again. So the market self-corrects anyway. Sure, there are costs associated with having done something bad in a particular case, but the market as a whole, the tens of thousands of commercial and treaty arbitrations taking place every day, don't give any reason, either in terms of how they function or the enforcement of the underlying awards, to believe that there is some widespread problem of arbitrators who have other roles, either as academics or counsel, corrupting the process or adversely impacting the process. So I just don't think that by banning the practice, we're solving a big enough of a problem. This is the proverbial launching a missile to kill a mouse type of things. And with that, I will close. Thank you.
Thanks, Nontas, for giving an interesting free market spin to this question of ban. I would now move on to Steve, please.
Thank you, Promit, and thank you to Amit and Nontas for starting us off. I think I want to start by saying I agree with Nontas that investment treaty arbitration and commercial arbitration are different. And double hatting concerns arise in particular in investment treaty arbitration because of the development of publicly available case law that can be applied to broader issues in a way that awards in commercial cases can't. However, it's really important to focus on the fact that double hatting isn't just a concern in investment treaty arbitration. Rather, there's a real reason to believe and to worry that allowing double hatting in investment treaty arbitration will more broadly damage international arbitration generally. And in particular, I think we should be concerned that one of the fundamental strengths of international arbitration is party autonomy, the right to choose your arbitrator. And in fact, allowing double hatting in this smaller field of investment treaty arbitration is creating a fundamental threat to party autonomy more generally. In particular, allowing double hatting encourages threats like shifting to courts, shifting to investment courts. It also, though, encourages criticisms that we've heard from very prominent arbitrators and commentators like Jan Paulsen and Albert Jan Vandenberg, questioning whether party appointment itself should be allowed at all. Jan Paulsen has called it a moral hazard, and they've raised concerns about bias where parties are allowed to choose their own arbitrators. I think if we care about party autonomy, and I think we should care about party autonomy, we need to push back on those sorts of proposals to shift to courts, to shift to no party autonomy to choose arbitrators. And one simple way to do that is to draw a black line against double hatting in investment treaty cases. And I don't think that Amit and I should have to prove to the audience that double hatting is a threat. Well, I think we need to tell you, and you need to listen to, is the concern that it has a potential to cause serious damage, while fixing it has very little cost. So we have a situation where little cost if we regulate double hatting and very significant benefits. We should also ask ourselves whether we should be concerned about the interests of the repeat players, as Nontas just suggested, in the development of arbitrators' careers, or whether we should be concerned about faith and the legitimacy of the overall system of international arbitration. Should we simply hold on to a certain status quo, as the other side, I think, is suggesting, while ignoring that one of arbitration's greatest virtues is that it adapts and it evolves? And in particular, investment treaty disputes are a recent phenomenon. If we go back 20 or 30 years, we didn't have these. And I think what we need to do is rethink the needs and approach in those cases because of the differences that exist in those cases, and not simply apply a method that we might be comfortable with in commercial arbitration to investment treaty arbitration. I want to briefly and quickly talk about some of the particular points that Nontas made. And I think we should start with the idea that we're not really hurting parties or hurting arbitrators. There are many disputes, many qualified arbitrators, and if we think we're going to regulate double hatting just in the investment treaty sphere, which I think is the right approach, we're not really preventing arbitrators from gaining experience, and we're not really preventing people from choosing qualified arbitrators. There's always more than one qualified arbitrator, and if we avoid the problems that come with double hatting, we don't tie parties' hands in a way that means they can't get qualified arbitrators, and we don't we don't impede people's ability to learn to be better arbitrators. And what we in fact do is we expand the pool of experienced arbitrators, we expand the pool of available arbitrators, we automatically increase diversity and representativeness. And if you take a step back and look at the statistics around double hatting, and you think about the pool of arbitrators who do investment treaty cases, the fact that there is currently a club is pretty stark when you look at those numbers. And by regulating double hatting, we help break that club and expand the pool of experienced arbitrators. And we do that recognizing that parties aren't free to appoint anyone already. As Amit explained, this is just one form of conflict, and we regularly tell parties they can't appoint certain arbitrators because of conflicts. And that's what this is. This is a form of conflict. And I think we all should ask ourselves, should we be concerned that pro-double hatting arguments are mainly coming from those lawyers who are in a position to most benefit from double hatting? And even if you don't think that people who double hat or law firms who use lawyers who are double hatting are misbehaving, the fundamental question is, why allow the perception that there's a risk of bias or the criticisms and then the response, including the greater regulation that this can lead to, if we can fix the problem with such a small cost? I'm also concerned that we hear, and we heard this a bit from Nantis, that we should trust the integrity of the people involved. I think this is similar to the sort of discredited arguments we saw, for example, in the English courts in the Chubb versus Halliburton case, where the basic approach from the low courts was, we know the arbitrator and we trust him. So therefore that's enough, despite the fact there might be an appearance of bias. Just trust us is not a basis for developing confidence and the acceptance of the legitimacy of arbitration more broadly. And it particularly isn't a basis for getting people to trust a system where consent to arbitration isn't contractual, but a standing offer to arbitrate through broad treaty language, as in investment treaty arbitration. So I think we need to move away from the just trust us system. The self-correction might be fine in the long term, but also self-correction doesn't help us in the particular cases where something has gone wrong. And if we can avoid those risks, and both the risks and the perception of risk, we've done the whole world of international arbitration a benefit. We also have to recognize that this isn't about necessarily people consciously misbehaving, but it's about the idea that people can compartmentalize. And most of us get uncomfortable if an arbitrator is appointed in a case where that arbitrator has also been involved in a related or similar case, because we know, despite the logic of a lot of decisions on challenges, that people can't compartmentalize. What's in one part of the brain isn't kept out of what's in the other side of the brain. And when we're talking about double hatting, that concern about compartmentalization is even worse, because the arbitrator is not only having to compartmentalize what he or she knows from one case, from another case, but an interest that person has in a particular outcome, which may benefit him or her or their client in another case. And so asking people to unconsciously avoid that sort of influence is asking the impossible. We already know it's difficult to address those sorts of issues through challenge procedures, because challenge procedures are pretty sympathetic to arbitrators, and the standard of bias to disqualify an arbitrator is typically very high. Why create this risk at all? If we have a bright line rule about regulating double hatting, we have a simple approach that avoids all the negative impact that comes with issues of double hatting. And finally, it avoids the potential tension between the party that appointed an arbitrator without knowing whether that arbitrator might be carrying the baggage of another case that they won't know about because of the confidential nature of procedures. So if I appoint an arbitrator, I don't know whether she has issues in a case where she's counsel that may make her want a different outcome consciously or unconsciously. I don't know that. I don't know that during the course of the case where she's my arbitrator, she doesn't get engaged in another case to act as counsel. So all these things can be easily avoided at low cost, and there really is no reason to accept it. Avoiding double hatting in the investment treaty system disarms those who will do greater harm to party economy and international arbitration more generally, which is why people should stick with where they started, which is to recognize double hatting as it's allowed now in investment treaty arbitration is a threat to the overall system of international arbitration and should be regulated.
Thanks, Steve. That was very insightful. I now request Dipen to have the last word.
Well, thank you, everyone. So I think it falls upon me to be the last speaker of the last event of this week, where we spend discussing arbitration topics. I will try to keep my points very pithy because the speakers before me have done an excellent job of setting out the various aspects of the debate. At the very outset, I must declare an interest. If double hatting is a sin, then I must confess my guilt. I am an arbitration practitioner who primarily acts as counsel in arbitrations, but I do from time to time sit as an arbitrator. And so I have to make that disclosure first. Now, we have heard about the pros and cons of double hatting to some degree today. I think it's very important for us to remember that this is not a new debate. It's been going on for about 12 to 13 years now. The Court of Arbitration for Sport, which sits in Switzerland, introduced rules in 2009, so 12 years ago, prohibiting double hatting as far as CAS proceedings were concerned. And they evocatively use the phrase that you cannot be a referee and a football player at the same time. Very appropriate for the Court of Arbitration for Sport. And again, in 2009, Philippe Sands QC gave a speech at the annual IBA conference where he said that double hatting is very bad for investment arbitrations. He said it is deplorable and awful and it should stop. So we have been talking about this for dozens of years. Nothing unusual in the field of arbitration. We like talking about things. We like debating things. And if nothing else, it allows us to have fun conversations on a Saturday evening on these topics, which is all well and good. But the key question, and for me, that is always the most important question when you're discussing changes in arbitration is, what do users want? Ultimately, arbitration exists not for lawyers. It doesn't exist for arbitrators. It exists for the users, the business people, the clients, the parties, the states who use arbitration. And I think the best available empirical data as to what users want are the surveys that the Queen Mary University do from time to time. They did one with my firm Whiting Case about a couple of years ago in 2018, where we asked respondents, what are the most valuable characteristics in arbitration that you actually like? And 40% of the respondents said they prefer flexibility and the fact that they can appoint arbitrators of their own volition. They don't get a judge imposed upon them. So that is something that they really value. It's among the top 3 things about arbitration that they like. And when they were asked to name the 3 worst characteristics of arbitration, things they hate about arbitration, they said they don't like how long arbitrations take, how much they cost. Very few, if at all, said they don't like double hatting or conflicts of interest. So if you look at the users, this is not something that is keeping them awake at night as something that is fundamentally wrong with arbitration. Now, this Queen Mary survey that I'm talking about dealt with arbitration as a whole. It was asking respondents about arbitration generally, not limiting itself to investor-state arbitration. And I think as Stephen has mentioned, there are some separate concerns that apply when it comes to investor-state arbitration, which are different from commercial arbitration. But there's a subsequent survey that Queen Mary did in 2020, specifically in the field of investor-state dispute settlement. And in that survey, they asked users specifically in the context of investor-state arbitration, they asked them a bunch of questions about double hatting and what do users really feel about it. And 65% of the respondents, 2 out of 3, said that restrictions on double hatting will reduce the availability of arbitrators that the parties can choose from. So that was a concern that was expressed by the users. And 61% of the respondents said that arbitrators should be allowed to act as counsel in other cases and vice versa. So again, I mean, based on the empirical data, and I think this is the best empirical data that is available before us as to what users actually want, double hatting seems to be more of a big deal to academic practitioners of arbitration and commentators who are concerned about the purity of arbitration. Jan Poulsen talking about the moral hazard of arbitration, Professor Vandenberg talking about the ethics of arbitration. I think all of that is well and good, but fundamentally, at least what the data is telling us is that users are more concerned about flexibility of the process and less concerned about the problem of double hatting. The second point which came up, and I think all the speakers raised it in one form or the other, is this whole idea of what impact this would have in the real life when it comes to diversity in arbitration. So we all know that arbitration, especially international arbitration, for the longest time has suffered a criticism of being pale, male, and stale. It's largely Western European white men with gray hair deciding things in the world of international arbitration. And there has been a significant desire to change things. It's from the context of gender, of having more women and making it more international and having more ethnic minorities involved. And the question you got to ask yourself is, what impact of creating this segregation between an exclusive cadre of arbitrators who sit as arbitrators and arbitrators alone, what impact that would have in the field of arbitration. And again, I think there you can look at what people are saying. Arbitral Women, which is an NGO that has been set up in the last 5 years, whose purpose is to advance the interests of women and to increase diversity in national dispute resolution. They published a report that was last year, and I'm quoting from that, where they said that a ban on multiple roles in arbitration would have a severe impact on gender diversity, and that imposing a ban on dual hatting would be tantamount to reversing progress made on gender diversity by the international arbitration community over the past years. So Arbitral Women, which is advocating diversity for women, doesn't like it. We are today speaking in the context of the India ADR week, and we have to ask ourselves, what would a ban or a prohibition on double hatting mean for people practicing arbitration in India or in Indian arbitrations? Now, we all know that historically, arbitrators in India have principally been drawn from retired judges. Now, retired judges bring a lot to the table when it comes to adjudication skills, but there has been a recognition that those retired judges tend to run arbitration proceedings much as they do court proceedings, and that is not what parties intended or sought when they chose to go for arbitration. And the question that listeners on this session have to ask themselves is that if there were to be a prohibition on double hatting in India, are there enough arbitral appointments going around that there will be practitioners today who will forswear their practice before courts and tribunals and say they're willing to sit exclusively as arbitrators? And if they would not, effectively, what practitioners in India are saying is retired judges would have the field to be sitting as arbitrators. And that pretty much is the only game in town. And there is a big question to be asked whether that is desirable for the continuous progress of arbitration in India. And I think that, in my view at least, that would seriously undermine a lot of the progress and change that has happened in Indian arbitration in the last decade. The third point, which I think came right at the outset, which was the issue about issue conflict and the fact that it is a particular problem in investor-state arbitration. And if for nothing else, at least in the context of investor-state arbitration, double hatting should be prohibited because it causes issue conflict. I think there are a couple of things I want to say to that. I think the first is international arbitration has done pretty well in coming up with a set of rules and guidelines when it comes to dealing with conflicts of arbitration. The IBA rules and the conflicts of interest of arbitration have been around for the better part of 2 decades. They have achieved universal acceptance. Indeed, the recent amendments to the Indian Arbitration Act have actually incorporated them into the main body of the legislation. And so the different lists, the orange list, the green list, the red list, all of that is well accepted mechanism. People understand the traffic light system and it works. And I think at the outset, there was a reference to the ICSID case involving Argentina. But I take the case, which was mentioned by Amit at the outset, as supporting my position, which is in that case where there was an issue of conflict, the parties relied on the IBA guidelines and conflicts of interest. They said that it was caught by the orange list. They said the arbitrator served as a counsel, and that issue was dealt with. And so given that you already have safeguards in the form of the IBA guidelines and conflicts of interest available, I do agree with Montes where he said that you're using a missile to kill a mouse or you're throwing the baby out with the bathwater, depending upon your preference of analogies. I think it is an overreaction when you already have mechanisms in place. And I think dealing with Stephen's point, where he mentioned the fact that in investor-state arbitration, you have people whose positions as counsel would somehow impede their objectivity as an arbitrator. I think we all know very well that in investor-state arbitration, there are many investors, many arbitrators, I beg your pardon, who exclusively sit as arbitrators, whose position on issues are extremely well known, and therefore they inevitably get appointed either by the state exclusively or by investors exclusively. And that is a position that international arbitration community is perfectly happy to live with. It's a practice, I must confess, with some degree of guilt we all practice in when nominating arbitrators. And I think if that is acceptable for arbitrators whose public positions on issues are certainly known, I find it difficult why we should be imposing a more stringent burden on counsel for whom issue conflicts is held up as a higher bar or a bigger challenge, which they have to surmount, which arbitrators who sit exclusively as arbitrators don't have to deal with. And I think I just want to end up with a final point, which is because I started with the confession of guilt, so I might as well end with elaborating on that confession. Shortly before I joined the session, I was filling in an acceptance form for sitting as an arbitrator. And in that, I was making very detailed disclosures because I work in an international law firm. We have 41 offices in 30 countries, and we have 2,700 lawyers. And I was making very extensive disclosures, which I spent the better part of 3 hours this morning sort of setting out in some detail for precisely the reason that Nontis mentioned, that I do value my independence, impartiality, and reputation. The last thing I want is to be challenged or on grounds of not making sufficient disclosures. And I think the system works because ultimately, if disclosures are made and parties know where the candidate for arbitrator stands, and if the arbitrator is appointed, well, that goes down to party autonomy. And obviously, if people have objections to it, the mechanisms exist for challenges. And I don't think that it is in the interest of international arbitration to be coming up with blanket prohibitions which undermine that principle of party autonomy. But with that, I hand over to back to Promit.
Thank you so much, Dipen, for such a resounding comeback to Steve. Before we move on to a few question answer from the audience, I would just like to take a poll back to see if Amit and Steve were managing to get a swing. I can request MCIA to run the poll, please. And can we share the results? I think the house clearly belongs to Dipen and Nontis. Congratulations.
Promit, can I make a point? And congratulations to Nontis and Dipen. I do think that it's important to recognize that you've got a panelist made up of law firm lawyers here who all sit as arbitrators and act as counsel. And I therefore think I tried to throw myself into the role of supporting the resolution that it was hazardous. And I worried that some people might think that we were compromised in defending that position because of where we come at things. At the same time, I think it's really important for people to recognize two things. One is this is an issue that's not going to go away. We've got draft conduct rules for investment arbitration that propose possibilities of either regulating this and banning this idea of multiple roles, or to increase disclosures. And as soon as you increase disclosures, you create complexity. And some of the questions that people have been asking, these become real issues, both more challenges to arbitrators, more challenges to awards, particularly because the idea of multiple roles will change over the lifetime of a case. In the investment treaty world, these cases may last for many years, and the lawyers and arbitrators involved will have their roles change in other cases during that time. So we cannot ignore this issue. And even if the general reaction is the way we've approached it tends to work, we cannot ignore it. And we also generally cannot ignore, we talk about the international arbitration community as if it's one thing. We cannot ignore the threat of greater regulation that goes beyond things like more disclosure, that will change things that are very important to both the legitimacy and the success of international arbitration. And if I passionately believe and Dipen was talking about the Queen Mary surveys, if we start to limit parties' ability to choose their own arbitrators, I don't mean pick individual X, but to appoint their own arbitrators, we are fundamentally moving away from what makes international arbitration work. So I don't think, even if the vote is it's not hazardous, I think it's a mistake to think this is going away, and it's a mistake to think that we can just say, aha, we all agree, therefore it's not a problem.
Yeah.
Sorry, not this.
No, I was going to say I fully agree that this issue is only beginning. I mean, Amit was talking about the big changes now underway in the investment treaty system with the will of states. So we cannot question it. It is what it is, and the treaty system is moving towards a kind of international judiciary mechanism. It seems to me we're moving away from the ad hoc constitution of investment treaty tribunals. At least under those multilateral treaties, it looks like we're moving sort of toward a more bureaucratized type standing tribunal situation. At least that's the active proposal of several states. So at the same time, if we're going to preserve the nature of arbitration, which is to have a system for the private resolution of disputes using people specialized or knowledgeable about the dispute with particular industry experience, knowledge of commercial practices, and things of that nature, then we must, it seems to me, keep ways of injecting that expertise into whatever tribunal we put in place. One of my sort of hobby horse ideas actually is to sort of start thinking about mixed tribunals between standing adjudicators and people from the markets, practitioners, whoever, subject to appropriate vetting, so that this type of knowledge and experience can always be up there on the bench, and we don't get into an ivory tower type of situation and a complete separation between the commercial reality and the adjudication mechanism.
And, just one question for you, Dipen. I think I'm just rephrasing a question from the audience. I know you referred to the White and Case survey a few times, but now that you've removed the debater's hat, who do you think benefits the most from double hatting, and how do the other participants in arbitration who are non-lawyers actually stand to gain if we do not ban double hatting?
I think it's kind of hard, right? Because as Stephen said, all of us are sort of primarily practitioners who sit as arbitrators on the side. But I generally think there's a chicken and egg problem, right? That effectively, if you have a blanket double hatting prohibition that kicks in, I think absent an idea the Nontas has, which I think is quite a good idea, that you have, and it's a bit like how the London High Court works, right? So for example, in the London High Court, you have, let's say, 25 permanent judges, but you have at least what they call 40 deputy High Court judges who are appointed for a term of 4 years. They are practitioners in London, tend to be largely barristers, but for at least 1 month of the year, they promise that they will sit 30 days as a judge. And the idea is that way you are getting practitioners some judicial experience, and you're also helping them figure out that whether a career as a judge is right for them. Now, I don't know whether that is the future for creating some sort of a super judiciary for investment arbitration where people have those kind of roles. But those kind of top-down changes are easy to make in domestic judiciaries. They're very hard to do in this chaotic world of investment arbitration. I mean, we've spoken a lot about investor-state arbitration, but investor-state arbitration, if we were just to look at the number of arbitrations, is a tiny fraction of the number of arbitrations taking place in the world. You've got maritime arbitrations, you've got trade arbitrations, you've got construction, commercial, blah, blah, blah. So I think part of the advantage of arbitration is chaos. The fact that you want particular sectors, particular businesses, particular trades to be able to make choices for themselves. And it may well be that investor-state arbitration will have to be treated as a sui generis kind of a situation with a particular bespoke solution, and the rest carry on in the usual way.
Thank you so much, Dipen. I think we are running out of time, so you still get to say the last word. But thanks to all the panelists for having such an engaging session with us. I'll now hand over to YMCIA for the concluding remarks.
Thank you so much, Promit. I think that was a fantastic debate and a fantastic way to end this India ADR week that we've had. We've seen some really interesting arguments from both sides, even though one side seemed to clearly, the audience seemed to agree with one side. But we've seen, we've heard about issue conflict. We've spoken about the differences between investment arbitration and commercial arbitration. Do we have to take that into account? Whether we can compartmentalize as a lawyer, as counsel, and as arbitrator. We've spoken about the diversity issues that this could raise. And each of these arguments we've spoken about both sides to each of these arguments. We've seen that it's not a clear-cut answer anyway. And I think, as Stephen said, if I may use his concluding remarks, this is an issue that's not going away. So it's good that we're talking about it. It's good that we're aware about it, and it's an issue that we're going to be speaking about again. So with that, I'm going to close this session and close this fantastic week that we have had, we've all participated in. Thank you to the MCIA. Thank you to all our speakers, all our sponsors. It was an absolute pleasure to have all of you with us during this week. Thank you so much.